Everyone.
Good afternoon, Judge. How are you?
I'm well. How are you today?
Doing great. Thank you.
We missed you yesterday.
Judge, personally, I missed you all, but otherwise, you already know, especially with that big calendar yesterday. But I'm here today.
All right. Good to see you.
Okay.
Let's see. It's a little before 2. We'll wait for everyone to get on the line before we begin.
Your reset date for SAT is going to be April the 26th.
Thank you. Good afternoon, Ms. Falk. Hope you're well.
Good afternoon, Your Honor. I am. How are you?
I'm good. Seems like we were just here.
Feels like definitely less than 16, 17 hours ago we were here.
Right. All right. Do we have any public defenders on the line yet?
Doesn't appear to be.
Okay.
Actually, we don't have many people in at all. It looks like people are just starting to be added.
There ain't no one in the waiting room, Judge.
Oh.
So they should be coming on soon. And I think we had a couple conflict cases, but I don't think we had a conflict attorney either. We didn't have anyone available for today.
Okay.
How many, just out of curiosity, state court, how many conflict cases were we showing? Because I didn't have any co-defendant cases or dual prosecution cases.
Looks like it was 2 altogether. Let me see here. Edric Hill and Mohager.
I'll make a note of that. Thank you.
Your Honor, can we take care of those 2 cases first, since
Yes, that's
been spoken to?
That's fine. Very good. Good afternoon, Program.
How you doing, Your Honor?
I'm doing well. Hope you are also.
Wonderful. So let's get it started. We're gonna bring up position number 6, Mr. Edric Hill.
Good afternoon.
Good afternoon, Mr. Hill. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. We are conducting this calendar this afternoon by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you, Mr. Hill. Mr. Hill, you've been charged in case 22 CR 002201F with simple assault. Let me just say that you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We do have public defenders on the line today. Unfortunately, they have a conflict with your case. As such, we had to get a conflict attorney to represent you. We do not have a conflict attorney present today, so you have a couple of options. If you would like to proceed pro se today, meaning without the advice of an attorney, you can proceed pro se. If you would like to have an attorney represent you, we'll have to reset you until tomorrow, at which time we will have a conflict attorney present. What would you like to do, Mr. Hill?
I would like to proceed.
Say it again?
I would like to proceed.
Okay, all right, thank you. Let's see, Mr. Howard, I see that Mr. Hill is recommended, is that correct?
Yes.
All right,
Only
thank you.
violence is 2005 simple battery conviction.
Okay. Ms. Webb?
Good afternoon, Your Honor. Good afternoon. How are you? Good to hear. This particular incident took place on April the 11th at 766 Plainville Drive. That's Plainville, PLAINVILLE Drive, Southwest Atlanta. The defendant explained to the responding officer that when he left for work earlier that morning on yesterday, that he was on the phone with their grandmother and heard his brother in the background threatening to break his video PlayStation game system. He then later returned, and upon his return to that home, he confronted the brother about why he broke his game station. In addition to these facts, Your Honor, allegedly there's been an ongoing dispute between the brothers regarding a car, but the defendant explained to the officer that he took the car that morning because he's the only one that holds a job in the home and puts the money into repairing that vehicle. When he returned back to the home, after hearing those threats, he confronted the brother about that game station. The brother said that he did not break anything, but the brother did tell the officer that he broke a TV, but that TV does not belong to the defendant, but instead it belonged to the grandmother. The officer spoke with the defendant's and the brother's grandmother, who informed him that the defendant entered the home with a knife in his hand, and when he confronted the brother, and that is when the police was called, although the defendant alleges that the brother had pulled a knife out on him during that dispute as well. After listening to all the parties' testimony, the officer determined that the defendant was the primary aggressor because he entered the home initially and confronted his brother with that knife. For those reasons, the state is recommending a $3,500 surety, no further contact with Mr. Mitchell Hill, that's Mitchell, common spelling, Hill, common spelling, a stay away from that incident location at 766 Plainville Drive, Southwest, 1 day anger awareness, and no alcohol, drugs, or weapons. In this particular case, we are concerned that whatever ongoing dispute that is happening between him and his brother, there seems to be a history of, bickering and violent bickering between the two. And we know that when these incidents happens with siblings, they're bound to argue, but they certainly cannot resort to using weapons as forms of self-help, Your Honor. So for those reasons, that is why the state is making a $3,500 surety bond recommendation today.
Thank you. Mr. Hill, courtroom 2, can you unmute for me, please?
Yeah.
Mr. Hill, who lives at that Plainville Drive address?
My grandmother, and I just moved there recently 2 years ago at the birthday of her girlfriend.
Okay, and does your brother Mitchell Hill live there too?
Yes.
Okay.
We can't get along. It's just that some circumstances.
Okay, hold on, Mr. Hill. You have the right to remain silent. Do you have another place to go besides that Plainville Drive address?
No, I have no other residence.
Ms. Webb, have you spoken with Mr. Hill, Mitchell Hill?
Our office did attempt to make contact with Mr. Hill, but we were not able to contact him. But sometimes people do call back after we make initial contact. So I'll double verify that and alert the court if anything is different, Your Honor.
Okay, and Mitchell Hill is your brother, is that right?
Yes, it's my younger brother.
Okay. All right, so based on your history, Mr. Hill, I'm gonna give you a $2,000 signature bond, which means you're gonna be able to sign yourself out, okay?
Okay.
You're gonna do that through pre-trial, and you're gonna have a 1-day anger awareness class. You can have no further violent contact with your brother, Mitchell Hill, and no drugs, alcohol, or weapons while out on bond. I'm gonna let you out, Mr. Hill, but you're gonna have to make sure to come back at your next court date, at which time, if you qualify for the services of a conflict defender, one will be provided for you, okay?
We'll be here.
All right, if you get into any other trouble with your brother, you're gonna be right back in here and you won't get a signature bond the next time, you understand?
Yes, Your Honor.
All right, do you have any questions for me, Mr. Hill?
No, Your Honor.
All right, good luck to you, sir.
All right, thank you, sir.
You're welcome.
The next conflict is, we got 2 conflicts we gotta do, then drop and go. Position number 8, Mr. Mohajay.
Good afternoon, Mr. Mohajay. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. I'm doing fine, sir. We're conducting this calendar by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Absolutely.
Thank you. You have been charged in case 22 CR 002202F with battery, simple battery, 2 counts. You're in the same position as the gentleman before you. You have a right to have an attorney present at these proceedings. We don't have a conflict attorney available today. You can either proceed pro se, meaning without the advice of a lawyer, or you can wait until tomorrow when we can have a conflict attorney here for you. Which would you prefer?
I would like to proceed, please.
Okay, just know, sir, that you have a right to remain silent. Anything you say can be used against you. Mr. Howard, it's my understanding that Mr. Mohager is also recommended.
Second arrest. Last was 2011 DUI conviction. But
Good
yeah,
afternoon. Thank you. Good afternoon, Ms. Duncan.
Good afternoon, Your Honor. How are you?
I'm well, thank you.
This incident occurred on April 11, 2022. Officers were dispatched to the location of 11130 State Bridge Road in Johns Creek, where the defendant was involved in a physical altercation with an employee. One of the victims was a Mr. Michael McGraw, and Mr. McGraw was trying to keep the parties separated. And during the altercation, the defendant swung his fist at this victim and wrapped his arm around this victim's neck. He used his finger to scratch Mr. McGraw on the right eye area surrounding his right eye. And there was an additional victim, Mr. Samuel Orglass, and that victim was shoved by the defendant. Given the facts and circumstances in this case, the defendant does have a 2015 DUI conviction. We are requesting a $3,500 total surety bond. That's $2,000 for the battery and $750 surety for each of the simple battery charges. No further contact with either victim. Stay away from the incident location. 1 day anger awareness, no alcohol, drugs, or weapons.
I only heard the victim, Michael McGraw. Is there another victim?
Samuel Orglass.
Spell the last name, please.
Orglas, Your Honor.
And this State Bridge Road address, what is that?
I am unsure, Your Honor. Let me check.
You said something about employees, so is it a business?
Well, yes, I believe it is a business. I believe he was involved in an altercation there and they were trying to break it up from what I can gather, Your Honor, and they were attacked. It's a Pastavino is the location. Pastvino.
All right, thank you. Ms. Mohager, do you have any reason to be at this Pastavino? If you'll unmute for me, courtroom 2, please.
Yeah. Can you say that one more time?
Yes, do you have any reason to be at this Pastavino located on State Bridge Road?
No, I don't need to be there.
Okay, and do you know these people, McGraw and Olas?
I don't know them, no.
Okay, all right, so it's gonna be a $2,000 signature bond through pre-trial, 1 day anger awareness class. Stay away from the Pastavino location on State Bridge Road. No further contact with Michael McGraw and Samuel Orlas, and no drugs, alcohol, or weapons while out on bond. I'm gonna give you a signature bond and let you out, sir, but you're gonna have to make sure that you show back up for your next hearing. Otherwise, they're gonna put out a bench warrant on you, okay?
Absolutely. Thank you, Your Honor.
All right, you're welcome. Have a good afternoon.
Thank you.
Your Honor, what's the breakdown on those bonds?
It's gonna be 1,000 for the battery and 500 for the simple batteries. Thank you.
Your Honor, we're going to courtroom 3.
All right, so Vogel, who do we have in courtroom 3?
Position 1, Judge.
All right. Good afternoon, Ms. Carter. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Carter, you have been charged in case 22 CR 002196Y with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
second. Last was 2013 trespass.
Ms. Webb?
Yes, Your Honor. This particular incident occurred on March the 10th, 2022 at the incident location with 6831-B Glen Lake Parkway, Sandy Springs, Georgia, around 7 a.m., where the Sandy Springs Police Department responded to a domestic dispute call, and the victim, Mr. Hidalgo Williams, that's Hidalgo, Hildalgo Williams, common spelling, informed the officer that he and the mother of his children were in a verbal altercation that turned physical regarding sharing responsibilities with getting their child dressed during the morning hours. At some point, the verbal altercation escalated and the defendant pushed Mr. Williams and started to scratch him and strike him in the chest area. He told her to stop and she pushed him again. And Mr. Williams, in retaliation, attempted to defend himself and grabbed onto her shirt in order to pull her away from him. The defendant continued to strike him in the face and near his eyes and lips. The party's two minor children, QW and LW, were present in the home in the living room area watching TV at the time, and the argument centered around getting minor QW dressed. The state is recommending a $3,000 surety for the battery offense and $500 surety for the cruelty to children offense. Third-party contact with the minor children, stay away from that incident location, no further contact with Mr. Williams, 1 day anger awareness, and no alcohol, drugs, or weapons. Our office did make contact with Mr. Williams, Your Honor, and he informed our office that the parties are no longer in a relationship and they no longer reside together at that incident location, and that the defendant has since moved out. And although he does not desire to see the defendant be prosecuted for these allegations, the state does have a concern that the reasoning behind calling the police was that Mr. Williams was informed by his probation officer to have documentation should any events or incidents occur between the parties, which suggests to the state that there has been a history of some type of violence between the two. Your Honor, for those reasons, we are concerned with the risk of reoffending, and of course that this incident involves two children, Your Honor. Nothing further at this time.
Thank you. Good afternoon, Ms. Gant.
Good afternoon, Your Honor. I do apologize for joining the call late. I was finishing up my interviews.
That's no problem.
Thank you. Miss Leah Carter is 30 years old. She was born in Atlanta, but relocated out of state, has been returned back to Atlanta, but has been here for the last 1.5 years. She has family here, including her parents and 2 sisters. She shares two children with Mr. William, a 6-year-old son and a 1-year-old daughter. She is the primary caretaker. We are opposed to any stayaways at 6831 Glen Lake Parkway. That is Ms. Carter's address, and she informs me that he does not live there. She does not want contact with him at this time. There is not a need for a one-time law enforcement escort, and Your Honor, we would ask for third-party transfer of the children. Ms. Carter has a bachelor's degree in healthcare management. She is gainfully employed at Emory Healthcare and has been so for the past 4 years. Today, we deny the allegations, and to the state's point, there has been some violence, but not on Ms. Carter's behalf. She informs me that she was defending herself. She states that he was yelling at her. In fact, she has recordings of this. She states that during this incident, he pulled her hair and he ripped her shirt. She also recorded that information as well. So for these reasons, we are asking for a signature bond. She does not have any history of violence. I am, again, opposed to any stay away conditions at her residence, and we are unopposed to the no contact order, but would ask for a third-party transfer. Thank you, Your Honor.
Thank you, Ms. Gant. Mr. Williams, I see you there. If you would like to address the court, this is your opportunity. You don't have to address the court, but if you would like to, I'll need for you to unmute yourself and I'll have to swear you in. Okay? Can you raise your right hand? Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, sir. Thank you. What would you like to tell the court?
I just wanted to say, like I said, the only reason why I contacted the police is because of my probation officer told me whenever I have contact like that, I need to have documentation. But since then, me and Leah haven't been living together. We haven't been together. And the irony of everything is literally yesterday when we found out that she had the warrant, we had literally just finished hashing everything out. Like I said, when I talked to the officer, I'm not trying to pursue no charges. I just wanted everything on paper to get in my PO for my end. And, you know, I'm not looking for nothing to come out of this. if you could find it in your heart to just drop everything against her, I would really appreciate it. Like they said before, we have 2 children that we're raising together, and I promise you from this day forward, it won't be any more incidents like this.
Okay, thank you, Mr. Williams. Do you live somewhere else besides the Glen Lake Parkway address?
Yeah, I moved out actually a day or 2 after this happened,
Okay.
and I haven't been there since.
Okay.
That's completely her resident now.
All right. So what I'm going to do is it's going to be a $2,000 signature bond through pretrial, 1-day anger awareness class. At this point in time, there's to be no further contact between Ms. Carter and Mr. Williams, but there can be a visitation of the children through a third party. So you'll have to go through a third party to have visitation. No drugs, alcohol, or weapons while out on bond. All right, so it's going to be $1,500 for the battery and $500 for the cruelty, making a total of $2,000. All right, good luck to you, Mr. Williams. Good luck to you also, Ms. Carter.
Thank you, Your Honor.
Okay, who do we have next?
We're going back to courtroom 2, Your Honor. This is going to be position number 2, Mr. Escorcia.
Good afternoon, Mr. Escorcia. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon, sir, and yes.
Okay, thank you. Mr. Escorcia, you've been charged in case 22 CR 002200A with driving while your license was suspended or revoked and hit and run. Is there a history, Mr. Howard?
This is second, 2019 DUI, Douglas County.
Ms. Webb?
Yes, Your Honor. This particular incident took place on April the 9th, 2022, around the 805 Roswell Creek Lane address in Roswell, Georgia. Roswell Police Department responded to a crash call where the caller reported witnessing a driver crash their gray Infiniti bearing Georgia tags CPZ 7320 in a tree, and the driver exited that vehicle and ran away. The responding officer noted a single vehicle crash with approximately 150 feet worth of tread marks on the nearby neighboring road. The officer noted that the car hit another tree before coming to a rest and that the driver and passenger side airbags were deployed. That officer was able to run the vehicle tags and return to the defendant, and that his license was suspended for DUI on March the 30th, 2022. 2 women did approach that investigation site while the officer was on the scene, and when he asked who they were were hesitant to tell their names until one of the juveniles asked whether her brother was there and that someone told her that her brother had been in a wreck. He asked them to identify themselves several more times and for the brother's name again, and they failed to do so. And then finally, once he revealed that he already had ran the tags and had their name, one of them said the defendant's first name spelling YONATON, which was the same name as the registered owner. Your Honor, the state is recommending a $2,500 surety bond with no driving and no alcohol, drugs, or weapons as a condition. In this particular case, we are concerned with the risk of reoffending. Even though the state is not moving forward on the hit and run charge, the defendant's license had been suspended and he had received notice of that suspension, and that suspension was just made effective within the past 2 weeks. In Your Honor, and he has that previous DUI arrest from from December 2019. Luckily, no one was hurt or injured in this case, but it could have definitely been much worse than just striking a tree, Your Honor.
Yeah.
Thank you, Your Honor. Mr. Jonathan Escoria is 21 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, including his mothers, his siblings, and uncles. He also has a daughter, a 4-year-old. He does pay child support, and he actively co-parents his daughter. Mr. Escoria completed high school. He informs me that he has been working at a roofing company for the past 3 weeks, and he does not have much to pay toward bond. He denies the allegations. He states that he has proof that his license is not suspended. He states that when he completed the terms of his DUI conviction, he states that his driving privileges were reinstated and that he has proof of that. Your Honor, I am asking asking for a signature bond on Mr. Escoria's behalf. He is recommended. And again, we are opposed to any driving restrictions if in fact he has an active valid permit or license to drive. Thank you.
All right, so for the suspended license, it's going to be a $500 signature bond through the jail. For the hit and run, $1,000 signature bond through the jail, making it a total of a $1,500 signature bond through the jail. No
And Your
driving.
Honor, the state is not proceeding on that hit and run charge. Since he struck a tree, we're not proceeding on that charge since it was a single crash accident and not involving another driver.
Are you going to null process that?
Yes, Your Honor. I will send a null process order to Ms. Bridgewater.
Okay, thank you, Ms. Webb. So it's just going to be a $500 signature bond through the jail for the driving while license was suspended. No driving unless you have a valid license, Mr. Escorcia, and no drugs, alcohol, or weapons while out on bond.
Yes,
All right,
sir.
good luck to you, sir.
Like I've told Wanda.
Hey, Mr.
Mr.
All right, thank
Yeah.
you.
Remain silent.
Your Honor, we have position number 3, Mr. Etheridge,
Okay,
number 3.
thank you. Good afternoon, Mr. Etheridge. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are holding by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Etheridge, you've been charged in case 22CR002199Y with simple battery, family violence, and possession of marijuana less than an ounce. Is your history, Mr. Howard?
6 total. Last was February 2022. Ag assault, reckless conduct, simple battery, suspended license. That's open 22 CP 206346. 2018 suspended license, misdemeanor possession of marijuana, arrest. 2016 suspended license, dismissed. 2012 suspended license, dismissed. 2011 false imprisonment. He got first offenders for that. Cruelty in the third, battery. The ag assault and that arrest was dismissed. That's it.
All right, Ms. Webb.
Your Honor, this incident took place on April the 11th around 2:15 a.m. at 322 Decatur Street, Southeast Atlanta, when the Atlanta Police Department responded to a domestic dispute call and were met with the defendant's wife, Ms. Kiera Harper. That's Kiera, K-I-E-R-R-A, Harper, common spelling, and his sister, who is the victim in this case, Miss LaPromise Dye. That's LaPromise, L-A-P-R-O-M-I-S-E, Dye, D-Y-E. Ms. Harper explained to the officer that the defendant came home and displayed visible frustration, and they had an argument that turned physical after she attempted to leave to give some space in the home, and the defendant demanded that she take their minor child with her, and she refused and told him to leave and take the child with him. The defendant then grabbed her by her shirt and attempted to force her outside and pushed her into the hall, and she slapped him in defense. The defendant left the location and returned, and when he did return into the home, he pulled out a camera out of a socket, according to his sister, Ms. Dye, and the two began to have a verbal dispute that turned physical, and the defendant allegedly punched, pushed, choked, and slammed her. The defendant then began throwing her belongings, entered her room and began throwing her belongings around in that room. At some point, the dispute exited outside the home into the hallway of that apartment building. And those two victims, an additional 2 women, appeared to the scene, and they were all in a physical dispute with the defendant, Your Honor. According to one of the witnesses at the scene, who was a neighbor at that location, said that she saw the 4 women punching and pushing the defendant and yelling and screaming, and that it's kind of common for there to be arguments taking place in that household, Your Honor, and that this is not the first incident that she's heard of people arguing from that apartment. And at some point, the fight was able to be broken up, and that is when the police was called. After hearing all the parties' testimony, the officer did find that the defendant was the primary aggressor and arrested the defendant. And he did have in his backpack his wife's handgun and approximately 7 grams of marijuana that he was carrying. Your Honor, the state is recommending a $7,500 total surety bond, $7,000 for the simple battery, $500 for the marijuana possession, a stay away from that incident location, no further contact with Ms. LaPromise Dye, and no alcohol, drugs, or weapons. Your Honor, the reason why we're making this recommendation is because the defendant is currently out on a $20,000 bond for that ag assault case that you've heard from pretrial. That was just from a month ago. Additionally, Your Honor, as we've heard from in the report from one of the testifying witnesses that there appears to be an underlying domestic matter going on in that household between the members, and that the state concerned that whatever's agitating the defendant will persist. And since there is children in the home, we are concerned with the risk of reoffending, Your Honor, and that's the basis for our recommendation today. Nothing further.
Thank you, Ms. Wood. Ms. Gant?
Thank you, Your Honor. Mr. Lonnie Etheridge is 35 years old. He has been in the Atlanta, Georgia area for 6 years with his family, including his sister and his wife. He is the proud father of one child that he shares with his wife, Ms. Etheridge, and he also has other children, ages 11, 9, and 7. He is involved in their lives as well. We are opposed to the stay away at 322 Decatur Street, as I understand it, and I've spoken to Ms. Etheridge. That is the residence that she shares with her husband, and my client informs me of the same. That is their residence. Ms. LaPromise does not live there. Mr. Etheridge completed high school. He is gainfully employed at New Birth Gym, but he states that employment will be ending in May. He denies the allegations, and as we heard from the statement and what's in the warrant, my client was actually attacked. Your Honor, I acknowledge my client's history. However, the ag assault case is open and he is presumed innocent in that case, as he is in the current case as well. I did not hear much about anything in the area of violence, and if so, it was over 10 years ago. Therefore, I am requesting a signature bond on Mr. Etheridge's behalf. And if Your Honor determines that he is ineligible, then a bond of no more than $1,000, that would be a signature for, well, a split bond. That would be a signature bond for the possession charge and $1,000 for the simple battery family violence. Again, we are opposed to the stay away, and I was not able to make contact with Ms. LaPromise Dye. His wife informs me that she is working and unavailable at this time, and they did not have a number for her. So I am unopposed to any no contact orders with Ms. Dye, but I am opposed to a stay away at 322 Decatur Street. Thank you, Your Honor.
Who is Ms. Dye to Mr. Etheridge?
That is his sister.
Okay, and Ms. Dye does not live at the Decatur Street address?
That is what I am told, Your Honor.
The reporting officer said that she did live there at that time. I'm not for sure if she's since moved out or plans to move out, but as of yesterday, she was residing there.
Okay. So it's going to be a $2,000 good bond, $1,500 for the simple battery, $500 for the marijuana possession. No further contact with LaPromise Dye. He can go back to the Decatur Street address, but he cannot go return if Ms. Dye is living there. If Ms. Dye is there, then he has to find someplace else to live until she moves out. If Ms. Dye is not there, then he can reside there. He's to go back the first time with law enforcement to make sure that Ms. Dye is not on the premises, and if she is on the premises, then he'll have to collect his belongings and find somewhere else to reside until this matter is resolved. Okay? No drugs, alcohol.
Your Honor.
Yes.
The last thing I heard, no drugs, alcohol. I think there was a pause. Is that your last statement?
Or weapons.
Okay, no drugs, alcohol, weapons.
Right.
Okay.
Okay. Anything further?
Nothing further from
the state.
All right. Good luck to you, Mr. Etheridge.
Thank you. Next, we have position number 4, Mr. Hardiman, position number 4. How you doing?
Good afternoon, Mr. Hardiman. How are you? I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, I agree.
Thank you, Mr. Hardiman. You've been charged in case 22 CR 002203J with certain acts on a bus, rail station prohibited, and criminal trespass. Is there a history, Mr. Howard?
46 total. Last was back in June for shoplifting out of Brookhaven. We got an open shoplifting and simple assault. 20 CP 191644. And open shoplifting in Brookhaven. 2020 shoplifting, another 2020 shoplifting. They just show as arrest for now. Another 2020 shoplifting, and another one. 2019 theft by taking. 2019 FTA for shoplifting. It's mostly shoplifting.
Thank you. Ms. Webb?
Yes, Your Honor. And this particular case took place on April the 11th, which was yesterday, at the Lindbergh MARTA station at 2424 Piedmont Avenue, where the defendant was found drinking a large bottle of strawberry margarita on the southbound car 302 car at 189. The defendant does have an active year-long suspension from MARTA that was issued on April the 2nd, 2021, and expires on May the 3rd, 2022. Your Honor, in this particular case, the state is making a recommendation for $1,000 surety bond, considering that the defendant did have prior notice that he was suspended from MARTA and was not to return to the premises, Your Honor, and considering those open cases. In addition to, Your Honor, that the state has a concern he is a possible flight risk, as he does have FTAs from his DeKalb trespassing cases from 2019. Nothing further.
I'm sorry, Ms. Webb, tell me again, what did he do on the train?
He was drinking a large strawberry margarita.
Okay. Ms. Gant?
Thank you, Your Honor. Mr. Brandon Hardiman is 36 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, including his mother. We are unopposed to the stay away if there is an active MARTA suspension in place. Mr. Hardiman completed the 11th grade. He is gainfully employed at Mr. Car Wash. He has been in that position for 2 years. He states that he does not have anything to pay toward bond, nor is his mother in a position to help him. We are denying the allegations today. I am requesting a signature bond, given the nature of the allegations. These are nonviolent offenses, and although my client has some history, he does have recent cases that are open, and the last FTA I heard about is 2019, and I show an arrest since that time. So for these reasons, Your Honor, I'm requesting a signature bond on Mr. Brandon's behalf, and if Your Honor determines that he is ineligible, then the lowest bond possible, please. Thank you.
I didn't know it was a margarita, Ms. Webb.
That's what it was cited as in the report. I believe it was one of those canned margaritas that they sell like at the grocery store, kind of like a margarita. They're kind of popular, but it was noted as a 750 milliliter bottle.
Did the police recognize him from an earlier incident or something of that nature?
Those facts are unclear, but it did state that he had the active suspension, so not for sure if they had a bolo out on them, or but it appears that they were able to recognize him because they pulled the suspension information.
Okay, would you unmute courtroom 2 for me, please? Mr. Hardiman, you know you can't go back to MARTA, right?
Yes, I know for sure now. I actually forgot about it.
Okay, just tell me that I'm going to let you out, but you have to tell me that you're not going to go back to MARTA, okay?
I'm not.
All right, so it's going to be a $500 signature bond for each charge, making it a $1,000 signature bond total through the jail. Stay away from MARTA and no drugs, alcohol, weapons while you are out on bond. I asked you that, Mr. Hardiman, because if you come back and you've gone back to MARTA, I'm not going to let you out next time, okay?
Okay.
All right. Good luck to you, Mr. Hardiman.
All right, thank you.
Thank you, Your Honor.
Welcome.
I'm sorry, Your Honor, I didn't get that bond amount.
It's $500 per charge, so $1,000 signature bond through the jail.
Thank you, sir.
You're welcome.
Next, we have position number 5, Mr. Hextall.
Good afternoon, Mr. Hextall. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Mr. Hextall, you've been charged in case 22 CR 002198H with criminal trespass. Is there a history, Mr. Howard?
I think I counted about 4. 2015 DWI conviction out of Virginia. public drunk. Last Georgia arrest was back in September. DUI, suspended license. He got first offender for sale of marijuana. This is cocaine. And possession of cocaine. That was from 2014. And he's a resident of Norfolk, Virginia.
Ms. Webb?
Yes, Your Honor. This particular incident took place on April the 11th at 160 Arcadia Circle Northwest, Atlanta. That's Arcadia, ARCADIA Circle Northwest. Atlanta Police Department responded to a trespass call at that location, and the defendant was sitting on the porch drinking a half-gallon of whiskey. When the officer asked him if he lived there, he did not respond, and the officer asked for his name, and he refused, and at that point, he was detained. The defendant then told the officer that he came back to retrieve the rest of his belongings, and when asked who he paid the rent to, he again went silent. The homeowners came to the scene and informed the officer that the defendant is a former tenant there who moved out due to a bed bug infestation with his former roommate, in which they presented a cash out receipt of returning that rent to the defendant for the previous month. The owner said that the defendant moved out on that prior Friday, which was last Friday, April the 8th, 2022, and cleared out his room. The state is making a recommendation for a $2,000 surety bond, a stay away from the incident location, no further contact with the homeowners, Mr. Frank Ballew, that's Frank common spelling, Ballew, Ballew, and Y Wong Ballew, that's WAI Wong, WONG Ballew. Our office did get an opportunity to speak with Mr. Ballew, and he said that the defendant attempted to enter the home through a window with knowledge that he was not to return to that property. And actually, the defendant admitted that to the responding officer as well. In addition to, Mr. Ballew said that the defendant had retrieved all of his belongings on that Sunday and that nothing was left for him at the home, and he has no reason to return, and they would like to seek a stay away order and no further contact with him, Your Honor. So for those reasons, the state is making that request for the $2,000 surety with the stay away and no further contact and no alcohol, drugs, or weapons while out on bond.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Andre Hextall is 28 years old. He is from Norfolk, Virginia, but he states that he relocated here. I do have an address for him that is different from the incident location. I will place that in the chat. Mr. Hextall completed high school. He also has 1 year of college. He has been unemployed, Your Honor. He states that he lost his job about a week ago because of some car trouble, and then he was unable to report to work. So he does not have anything to pay toward bond, Your Honor. I am asking on my client's behalf for a signature bond. He denies the allegations. We are unopposed to the stay away and the no contact orders, and we did not really hear anything in my client's history regarding to being a habitual offender with regards to criminal trespassing. So therefore, Your Honor, I am requesting a signature bond on Mr. Hextall's behalf, and he is recommended, Your Honor. Thank you.
All right, it's a $3,000 signature bond through the jail. Stay away from the Arcadia Circle address. No further contact with the Ballews. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Hextall.
Thank you, Your Honor.
Next, we have position number 7, Mr. Mangum. Position number 7.
Good afternoon, Mr. Mangum. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon, yes, sir.
Thank you. Mr. Mangum, you've been charged in case 22 CR 002197G with 2 counts of theft by deception. Is there a history, Mr. Howard?
20 total. Last was December 2021. Forgery in the 4th degree. Failure to appear for forgery and theft by deception. May 2021 probation violation. He's on probation in Cobb, criminal damage to property. He was convicted for that and obstruction in May 2020. Got a shoplifting bind over from 2019 out of East Point. 2019 probation violation, robbery by sudden snatch. What else? 2019 theft by deception, forgery, 4th degree, forgery. They both was transferred to state court. He got convictions in 2018 for identity theft fraud, forgery in the 3rd degree, forgery in the 1st. More financial transaction card thefts. 1, 2, 3, 4. It's about 5 or 6 counts. I'll leave it at that.
Thank you. Ms. Duncan?
Yes, Your Honor. In this case, the events occurred on December 24th, 2019 and December 24th, 2020. The defendant in this case went to the location 5805 State Bridge Road, which is a Hobby Lobby. On the first instance, the 2019 instance, he went into the location and purchased several items totaling $313 after tax, which included home decor and a $250 gift card. The purchase was made with a check that was confirmed as fraudulent by Bank of America. And the identity of the defendant was able to be ascertained or possibly identified through the use of multiple Hobby Lobby location BOLOs. And there were comparisons made of theft reports from other places that were filed by Cobb County and things of that nature. The warrants additionally go on to state that on December 24th, 2020, the defendant returned to the business of Hobby Lobby at that same location and made additional purchases with the use of the gift card that was purchased previously, totaling the purchases $224. Given the defendant's history, Your Honor, we have a concern about the risk of reoffense. As you've heard, the defendant has an extensive history with theft by deception and other theft crimes. So for these reasons, we are requesting a bond in the amount of $6,000 surety. That's $3,000 per count of theft by deception. A stay away from all Hobby Lobbies, no alcohol, drugs, or weapons.
Hey, Ms. Gant?
Thank you, Your Honor. Mr. Brandon Mangum is 32 years old. He is a long-term Atlanta resident. He has family here, including his mom and his wife. He has been married for 4 years, and he is the proud father of 4 children, ages 15, 17, 10, and 8. The children are in the home with him and his wife. Your Honor, we are unopposed to a stay away at 5805 State Bridge Road, the incident location. However, we are opposed to a stay away from all Hobby Lobby locations. Mr. Mangum completed high school. At this time, he is unemployed. He informs me that he has been incarcerated for the past 2 years. Your Honor, he denies the allegations. He does not have much to pay, if anything, toward bond. Therefore, I am requesting a signature bond. And if Your Honor determines that he is ineligible, then the lowest bond possible, as he will not be able to pay anything toward bond. Thank you, Your Honor.
All right, so it's going to be $1,000 good bond on each charge, making for a total of a $2,000 good bond. Stay away from all Hobby Lobbies, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Mangum.
Thank you, Your Honor.
Thank you.
Who do we have next? Courtroom 2, you're on mute.
I apologize. It's position number 9, Mr. Powell.
Okay. Good afternoon, Mr. Power. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Power, you've been charged in case 22 CR 002207B with simple battery family violence and hindering persons making an emergency telephone call. Is there a history, Mr. Howard?
6 total. All of history come out of South Carolina. Last arrest was 2019, kidnapping, neglect by legal custodian, domestic violence, 1st degree. Before that was the 2009 arrest for simple assault. 2005, possession of marijuana, misdemeanor. 2005, criminal domestic violence, 1st degree. and possession of a controlled substance, well, marijuana, and the 01 trespassing, malicious injury to property, that was dismissed. He's a resident of Moncks Corner, South Carolina. That's it.
All right, Ms. Duncan.
Your Honor, this incident occurred yesterday on April 11th, 2022 at about 2:54 in the morning. Officers responded to the location in reference to a dispute. Upon arrival, officers were met with the victim in this case, Miss Chloe Tillery. Chloe is spelled Chloe. Tillery is spelled Tillery. Miss Tillery is the daughter of the defendant. She stated to officers that the defendant had been drinking throughout the night, and she told officers that he began acting aggressively and belligerent by screaming and getting in her face. She told officers that the defendant, she told the defendant, my apologies, that she would call the police if he did not calm down. The defendant continued to be aggressive towards Miss Tillery and belligerent. When she attempted to call 911, the defendant slapped the phone out of her hand, and when she attempted to retrieve the phone off the ground, the defendant jumped on her back and they began to fight over the phone. At that point, Ms. Tillery did advise officers that she bit the defendant in this case out of self-defense to get him off of her. There was a witness of the altercation, which is a stepson of Mr. Powers. He intervened and said that he was attempting to help Ms. Tillery get Mr. Powers off of her back. Our victim advocate was able to reach out to Ms. Tillery, and she stated to our victim advocate that they are not from Georgia, that the incident location was just an Airbnb, that they were here to visit. She stated to our victim advocate that the defendant just came into her life when she was 18 years old. So she's trying to build a relationship with him. However, he tends to get very violent when he drinks, and she's fearful of him when he drinks. She stated to our victim advocate that she would like no violent contact. We have a concern here in this case, Your Honor, given the flight risk. Most of his history comes out of South Carolina. It is stated that he is from Moncks Corner, South Carolina. So given the facts and circumstances in this case, Your Honor, we are requesting a bond in the amount of $4,000 total surety. That's $2,000 for the simple battery, and $2,000 for the hindering a person from making a 911 call. Those are surety. We would ask for no further violent contact in this case, Your Honor. 1 day anger awareness, no alcohol, drugs, or weapons, and an ADET.
Ms. Camp.
Thank you, Your Honor. Mr. Justin Powers, 37 years old. He in fact informs me that he is a resident of South Carolina, and he states that he was in fact here visiting with his family, including the complaining witness, Ms. Tilley, and his wife. Your Honor, Mr. Power obtained a general equivalency diploma. He is currently employed at Fence Me In. However, he informs me that the funds are limited, and that he is in possession of the credit cards, and that his family will not be able to access funds to get him out of jail. In fact, they're waiting for him to be released so that they can go home as a family. Your Honor, we are denying the allegations. We heard a lot about Mr. Powers' background. However, I believe I heard about arrest. I did not hear dispositions for the 2019 kidnapping, domestic violence matter. I did not hear a disposition for the simple assault. I believe I heard a conviction for trespassing in the mid-2000s. Your Honor, I did not have the occasion to speak with Ms. Tilley, but I see that she's on the line, so that I will defer to the court's ruling. My client wants to continue having contact, as again, this family was visiting here from South Carolina. We are opposed to the alcohol, drug, and evaluation and treatment. I do not believe that the state has put forth a sufficient basis for that order or for that request. And although my client has history, I did not hear about any FTAs. So that I do not believe that he is a flight risk, Your Honor. Thank you.
Thank you. Let's see, Ms. Tillery, I see you there. If you would like, you don't have to address the court, but if you would like to address the court, you'll have to unmute yourself and activate your camera, and I'll have to swear you in. So if you would like to address the court, now is your opportunity. Okay, it appears that Ms. Tillery does not want to address the court. Anything further, Ms. Duncan? Ms. Scant?
Nothing further from the state, Your Honor.
All right.
And
Yes,
yeah,
Ms. Scant.
nothing further. I believe that I requested a signature bond, but if I did not, a signature bond, Your Honor, and again, an order for no violent contact. Thank you.
Okay. It's going to be a $500 good bond on each charge, making for a total of $1,000 good bond. No further violent contact with Chloe Tillery, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Power.
Thank you, Your Honor.
Thank you, John.
You're welcome.
Next, we have position number 10. Position number 10, Mr. Stewart.
Good afternoon, Mr. Stewart. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, I do.
Thank you. Mr. Stewart, you've been charged in case 22 CR 002204Y with battery, family violence, and simple battery. Is there a history, Mr. Howard?
Yes, history out of New York and New Jersey. Last was 2010 grand larceny conviction. Yeah, the 02 conviction out of Georgia for robbery. 01 conviction for theft by unlawful taking. His cycle says battery DV and felony obstruction from 4/11/2022. I'm not understanding that, but that's all I got out of Hateville.
Duncan?
Yes, Your Honor, this incident occurred on April 11, 2022, at Hammers, located at 898 Virginia Avenue in Hateville. On this occasion, Your Honor, an officer was waved down by several patrons yelling while doing a area check. And the people were yelling that they're in there beating up the police. So officers rushed into the location. They found the accused and defendant in this case in handcuffs by Deputy Jimmy Taylor, who is a retired deputy with the Fulton County Sheriff's Office, who was working an extra job at the location in a uniform displaying sheriff. The defendant in this case was witnessed in a dispute with his wife, where he slammed her head area on the table and grabbed her by the neck. He struck her in her face with the closed fist multiple times, causing substantial visible bruises to her face. And when Officer Taylor attempted to break up the altercation, he diverted his aggression toward victim Taylor and started to punch him with closed fists as well. There were several bystanders that were eventually able to pull the defendant off of victim Taylor, and he was able to successfully be handcuffed. Our victim advocate did make contact with the victim in this case, Your Honor. She stated that her and the defendant have been married for 3 years and that they live together, but they share no children. She stated that she wants no contact with the defendant and that she hit her head, and stated that she couldn't even remember being slammed or grabbed by the neck on the table, but she does remember waking up on the floor, and she also remembers being punched in the face. She suffered an injury to her head where she received 7 stitches, Your Honor. And given the facts and circumstances in this case, we have a concern for the safety of the victim in this case, Your Honor. And given the violent nature and the facts alleged, we are requesting a bond in the amount of $6,000 total. That's $3,500 for the battery's family violence and $2,500 for the simple battery. No further contact with the victims in this case. Let's stay away from the incident location and wherever the victim, his wife will reside. She noted to our officers that she will or has left the location. So we would ask that he stay away from wherever she goes. And 1 day anger awareness, no alcohol, drugs, or weapons. And given that, that's what we request, Your Honor.
Can you spell the name to the victims, please? Alleged victims.
The names of the victims, first is Jimmy Taylor, Jimmie, Taylor, common spelling. That's the retired officer. And the wife is Nina, Nina Egson. And I apologize if I did not pronounce that correctly, but it's Egson.
All right, Ms. Gann.
Thank you, Your Honor. Mr. Yusuf Stewart is 41 years old. He has been in the Atlanta area for 6 years. He does have family here, including his cousins, aunts, and he also has a child here, age 11. He informs me that he is the primary caretaker. Your Honor, Mr. Stewart completed high school. He does have some college credits. He is gainfully employed at Emory Healthcare Systems. He has been in that position for the past year. He denies the allegations. Your Honor, I received a call from Ms. Egson, Nina Egson, moments before this hearing began, and she informed me that she wants to have contact with her husband. Your Honor, regarding, I would ask that the court implement a no violent contact order, and I'm happy to put the number at which from which Ms. Egson called me in the chat. Your Honor, we are opposed to any stay away orders. We are opposed to any no contact orders with Ms. Egson. We are unopposed to any no contact orders with Mr. Jimmy Taylor. I am requesting in this case a signature bond on Mr. Yusuf's behalf, and if Your Honor determines that he is ineligible, then a bond of no more than $1,000, and that would be $750 for the battery family violence, and the simple battery $250. The basis for my bond request, Your Honor, is that he does have community ties here, and although he has some history, the 2002 robbery, I believe that is 20 years ago, far too remote for the court to consider. And as far as the charge in 2022, I do not believe that I heard a disposition in that case, and he is presumed innocent in that case as well as this case, Your Honor. Thank you.
All right, for the battery family violence, it's going to be a $2,000 good bond. For the simple battery, it's going to be a $1,000 good bond, mixed for a $3,000 good bond. No further contact with Jimmy Taylor. At this point in time, no further contact with Nina Egson. He's to stay away from her residence. And if there's for visitation with the children, and there has to be third-party transfer, no drugs, alcohol, or weapons while out on bond.
And Your Honor,
yes,
may I request a one-time law enforcement escort if he has belongings there?
Of course. So, Mr. Stewart, you can go back to that. Well, if she's not there, he can be. It was my understanding from Ms. Duncan, Ms. Gant, that Ms. Egson was no longer at the residence that they shared. So, if she is there, he can have a one-time escort to pick up his belongings. If she's not there, then if he desires to stay there, he can stay there. Is that what you said, Ms. Duncan?
Yes, that is what I said, Your Honor. I would also like to ask, would there be a stay away from that Hammers location?
Yes, he's not to go back to the Hammers in Hapeville. All right, good luck to you, Mr. Stewart.
Thank you, Your Honor.
Thank you.
300. Next, we have position number 11, Mr. Stokely. Position number 11.
Okay, thank you. Good afternoon, Mr. Stokely. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, Your Honor.
Thank you. Mr. Stokely, you've been charged in case 22 CR 002205A with battery family violence. Is there a history, Mr. Howard?
6 total. Last arrest was 2016. Participation in criminal street gang activity. That's 16 CP 159900. Open possession of controlled substance, Schedule 2, 16 CR 007 152A. 2016 probation violation, driving without a valid license. He got PTI in 2016 for the Schedule 2, sale of marijuana, possession of a knife or a firearm during a commission, possession of a controlled substance in a drug-free commercial zone. That's it for the most part. Yeah, that's it. And he got a bench warrant too.
Okay. Ms. Duncan?
Yes, Your Honor. The date of this incident was March 1st, 2019. The victim in this case is Akira Cody. That's spelled Zakira, Cody, Cody. Officers responded to the location in reference to a domestic dispute. Upon arrival, officers were advised by Cody, who is the victim in this case, that the defendant, her son's father, had contacted her via Instagram to see his son. She stated that her friend gave her a ride over to the defendant's apartment so that he could see his son. She advised the officers that she met the defendant outside with the baby and they hung out for a few minutes. She said to the officers that she owed the defendant about $50, so she left to get the money out of the bank. And the victim in this case told officers when she returned, she walked into the residence and a family member advised her that the defendant was upstairs. She walked up the stairs and she entered the bedroom and she found the defendant in this case lying in the bed with another woman. She stated to officers that she was surprised, but she didn't make a big deal out of it. She stated to officers that the defendant in this case immediately jumped up and struck her in the face and attempted to push her out of the room. She stated to the officers that she told him to get off of her so that she can leave. She advised officers that she left out of the location and relocated to the front leasing office to call 911. Upon officers' arrival, officers noted that the victim in this case, Ms. Cody, had a red left eye, but advised that it was a scratch from her son. However, we are concerned given the facts and circumstances in this case. And we will request a bond in the amount of $3,500 surety for the battery family violence, no further contact with the victim in this case, third party child transfer, 1 day anger awareness, no alcohol, drugs, and weapons.
Have you spoken to Ms. Cody, Ms. Duncan?
We attempted to contact her, the number that was provided. However, that number apparently belonged to her mother, and she said that she would pass along our contact, but we haven't received any follow-up yet.
Ms. Gant?
Thank you, Your Honor. Mr. Juan Stokely is 26 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, including a fiance and his parents. He, in fact, shares a child with Miss Zakira Cody, a 3-year-old son. He is actively involved in that child's life. Your Honor, Mr. Stokely completed high school. He works for Jolly Construction, that is a family-owned business. He has been in that position for the last 2 years. He denies the allegations. He informs me that the complaining witness, Ms. Zakira Cody, had been told not to come to his residence. She came there uninvited, and when she found him with his fiance, she made a scene. He told her to leave, and then after that, she got mad and called the police and made up these allegations. Mr. Stokely does not want to have any contact whatsoever with Ms. Cody. Therefore, we are unopposed to the no contact orders. We would, in fact, request the third-party transfer. And for my client, Your Honor, I am requesting a signature bond. If Your Honor determines that he is ineligible, then a bond of no more than $1,000. And the basis, of course, is the last contact with law enforcement was in 2016. I understand that there is a bench warrant, but I don't have any further information regarding that with regard to being related to violence, Your Honor. Thank you.
All right, so it's going to be a $5,000 signature bond through the jail. No further contact with Ms. Cody. stay away from Ms. Cody's address, residence. He can have visitation with his child, but it will have to be through a third party. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Stokely.
Thank you, Your Honor.
Last but not least, Your Honor, hopefully I didn't miss anyone. Position number 12, Mr. Williams.
Very good, thank you. Good afternoon, Mr. Williams. I'm Judge Eric Moyer. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon. Yes, sir.
Thank you. Mr. Williams, you've been charged in case 22 CR 002206C with battery family violence. Is there a history, Mr. Howard?
12 total between Georgia and Alabama. I give you Alabama first. 2017 violation of probation. 2017 burglary. 2016 property crimes, burglary third degree, or 2017 public order crime. Last arrest overall was back in October, 4 counts of probation violation. He's on probation in Fulton, interference with government property, 18 SC 167172. Robbery by sudden snatch, 19 SC 164760. Shoplifting, 18 SC 161575. Theft by taking, 18 SC 161511. Each charge got a different year of probation. One got 4 years, one 9 years, one 7, other than 5 years probation. Let's see. 2019 failed to appear. That was out of DeKalb County. A trespass conviction from 2018. It was amended from a shoplifting. Simple battery, criminal trespass, simple assault conviction 2017 out of Columbus. That's it. His first cycle was a juvie cycle. So that's it.
Thank you, Ms. Duncan.
Yes, Your Honor. This incident occurred on April 11, 2022. Officers were dispatched to 5401 Old National Highway, which is the Biscayne Apartments in South Fulton. Upon arrival, there were firefighters on scene who stated that a woman named Qualethia Brown, that's Qualethia Brown, common spelling, advised them that she was assaulted by her child's father, the defendant in this case. Ms. Brown stated to officers that she was involved in a verbal dispute with the defendant because she wanted him to stop playing video games. She stated to officers that the defendant became angry and began yelling in her face. Ms. Brown stated to officers that when she entered the bathroom, the defendant grabbed her and threw her on the ground. Ms. Brown also stated to officers that Mr. Williams, the defendant in this case, slammed her head into the ground. Officers observed swelling and a laceration on her right eyebrow. The officers then spoke with the defendant in this case, and he stated a different story as to why Ms. Brown received her injury. And he said initially that she just fell on the bathroom floor. After officers spoke with the defendant, he was detained. He changed his story and said that the victim in this case received her injuries because he pushed her on the floor after she drew a knife on him. He also stated some other things about that they had agreed to lie to the firefighters about what had happened, but she went outside and told the firefighters a different story. Given the facts and circumstances surrounding this case, Your Honor, due to the fact that the victim in this case did sustain visible injuries, and at one point the defendant admitted to pushing her on the floor, and given the defendant's violent history, as pretrial has stated, we are requesting a bond in the amount of $4,000 surety, no further contact with the victim in this case, third-party child contact. She noted to the victim noted to the officers yesterday that they both live at that location, so we would ask for a stay away from that location, the Biscayne Apartments, 1 day anger awareness, and no alcohol, drugs, or weapons.
Ms. Camp.
Thank you, Your Honor. Mr. Daquan Williams is 24 years old. He has been in the Atlanta, Georgia area for 3 years. He has family here, including his mother and his uncle. He shares a 5-month-old son with the complaining witness, Calethea Brown. Your Honor, Mr. Williams informs me that he does not live with Ms. Calethea Brown. I am happy to put his address that he provided to me in the chat. Mr. Williams obtained a GED. He completed 12th grade in high school. He has been employed at Checkers for the past 4 months, and he informs me that he is about to be promoted. He denies the allegations, Your Honor. He states that he was in fact grabbed from behind and attacked, and that he was merely acting in self-defense. He informs me that he does not want to have any contact whatsoever with Ms. Brown. Therefore, we are unopposed to any third party no contact and stay away orders, provided that it's not at my client's address, which I will place in the chat. I am requesting a signature bond on Mr. Williams' behalf, and if Your Honor determines that he is ineligible, then a bond of no more than $1,000. Thank you.
Your Honor, if I may to correct the record, our victim did state, to my correction, he does not live there. However, he does have a few items there. So she said that she would give those items to his mother. So I would just like that noted in your recommendation, if the court pleases.
All right, so it's going to be $1,000 good bond, no further contact with Ms. Brown. Stay away from the Old National Highway address. He can have visitation with his child through a third party transfer for the visitation, no drugs, alcohol, or weapons while out on bond.
We had a network error. Can you give me that bond amount again, please?
Yes, $1,000 good.
Thank you.
All right. Anything further on Mr. Williams?
Nothing further from the defense, Your Honor.
Nothing further. His belongings will be transferred to his mother, so I'll just put that in the notes.
Okay, very good. Good luck to you, Mr. Williams.
Thank you.
Your Honor, we completed here in courtroom 2, unless I missed someone.
I think you got everybody. Thank you so much. We appreciate it.
All right, thank you. Have a good one.
All right, you do the same. We'll see you next time.
All right.
All right, Ms. Bridgewater, whenever you are ready.
Can everyone hear me?
Yes.
Okay, very good. Again, the reset date for the SAP calendar is going to be April the 26th. Position number 1 is reset further notice with a $2,000 total SOB through pretrial. Position 2 is being reset further notice with a $500 SOB through pretrial. That second charge is being null pros.
That's SOB jail, right?
It's SOB through the jail. That is correct. Position number 3 is reset to the SAP calendar with the $2,000 total good bond. Position 4 is being reset. Just lost my paperwork. I'm sorry, you guys. I'll come back to that one.
It'll be a $1,000 SOB through the jail, $500 for each charge.
Okay, if everybody heard that, then good. Just 1 second, Judge. 1 second. I kind of got it. Okay, that was number 4. Number 5 is being reset further notice with the $3,000 SOB through the jail. Position 6 is being reset further notice with a $2,000 SOB through pretrial. Position 7 is being reset to the SAP calendar with a $2,000 total good bond. Position 8 is being reset further notice with a $2,000 total SOB through pretrial. Position 9 is being reset to the SAP calendar with the $1,000 total good bond. Position 10 is reset to the SAP calendar with the $3,000 total good bond. Position 11 is being reset further notice with the $5,000 SOB through the jail. And position 12 is
Good.
reset SAP with the $1,000 good bond. Are there any questions, comments, or otherwise?
Who we got tomorrow? Judge, you know?
I do not know. I'm sorry.
It's fine.
You want me to?
No, I gotta go. I'm about to clock out now. See y'all tomorrow.
All right.
So is that good with everybody? Are there any other questions, comments, or otherwise?
Sounds accurate to me.
If not, everybody go grab a teaspoon of that sunshine.
Thank you.
All right. See y'all next time. Have a good evening.
Okay.